back. The lens is back on the Uniform Civil Code debate due to the actions of one Muslim couple in Kerala who wanted to secure the inheritance for their 3 daughters. Advocate and actor C Shukkur and academic Dr. Sheena decided to get remarried after 29 years. Their first marriage was a nikah under Sharia law, while the latest union is a registered marriage under the Special Marriage Act. Now, under Sharia law, their 3 daughters would not have any rights to all of their assets. Their inheritance would only be 1/3, while the rest of the assets would go to other male relatives. But under Indian law, they will become legal heirs to all of their assets. The couple says they wanted to ensure that there was no legal challenge to the inheritance of their children, adding that while their male cousins have full rights, it is discriminatory that they don't have the same, just because they are women. Muslim clerics, meanwhile, have called the remarriage a drama, calling the couple selfish for not extending the inheritance beyond the children. But why should they? But the question remains, shouldn't parents have the full right to secure an inheritance for their children, no matter what the gender? Has the Kerala couple shown the legal barriers women face under the Sharia law and made a strong case for the Uniform Civil Code? Joining me on the show is the father who wanted to protect the inheritance of his daughters, C Shukkur, who is actor and also an advocate. We also have Faizan Mustafa, constitutional expert. Faizan Mustafa, I'm going to come to you. The inheritance under Muslim laws were considered progressive during the time of Prophet Muhammad. It was supposed to change with changing times. But isn't it a fact that because it did not, it appears to be anti-women?
Maria, there are 2 things. One, we need to understand that Islam was the first religion and first legal system which gave absolute property rights to women. And out of some 11 first category heirs in Islam, which are mentioned in Quran, as many as 9 are women. Now, having said that, if you look at how the law stands today, any Muslim in his life, through hiba or gift, can give his entire property to anyone. So in this case, the father could have made a gift of entire property in favor of 3 daughters. So there was an option available. Now, when you give your property in gift, the effect is that the property must go out of your possession immediately. That is the law of the gift. When you give property or want to give property through inheritance, inheritance operates on your death. So you are not a loser of the property. Ideally, law to be progressive, there should have been, internal debates.
Yes.
And the ulama could have opted for a more liberal interpretation of Islamic law.
Which hasn't happened.
Just 1 minute. I don't hold a brief on for ulama, but let me just state the law. You see, any Muslim, or for that matter, anybody, has a right not to opt to be governed by any religious law. So in case of adoption, for instance, there is a judgment of Shabnam Hashmi, where the court said that she has a right to adopt. So the couple in this case is well within their right to opt for the Indian Succession Act, which is more gender neutral, so to say. And let me correct you, Maria, it is not 1/3. The 2/3 of the property will go to daughters under the current Muslim law in India, and 1/3 will go to the nephew, or to the uncle.
Yes.
That's what the law is right now.
Yes.
But within the Sharia itself, if you look at the Shia law, under the Shia law, the entire property will go to the daughters. And that's why many Sunni Muslims do opt, who have daughters, to become Shias, so that their daughters...
I get that. Faizan Mustafa,
it's a complicated thing,
It's a very personal thing here, and we are 3 girls. So, Mr. Shukkur, my question then is...
There, but I don't think there was a marriage It was a registration. The marriage has already happened.
So why have this marriage? But Shukkur Vakil, the fact is that taking refuge under the Special Marriage Act to avoid religious laws is not new. In fact, this is something which has happened and almost being seen as the very purpose of enacting Special Marriage Act. The question here is, could you have taken the route of gifting, as is being talked about? Yes, there are challenges of inheritance and the debate that should have happened among the Muslims hasn't happened. And Sharia is lopsided and it is anti-women.
With due respect, I'm
Yes.
Saifam Mustafa sir is a very prominent scholar in Islamic, especially in Muslim personal law. I am. My concern is not the property inherited by daughters. I want to be my daughters have the same legal status and property status that is enjoyed by the counterpart of my daughters. They belong to Hindu and Christian community. Now, they had the same legal status, the same equal right that is enjoyed by the other girls and other daughters belong to Hindu or Muslim Christian family. That is my. I want to prove before the society they have the equal right property, just other daughters, other community. The second one, this is not a solemnization of marriage under Special Marriage Act. According to as said by Mustafa sir, this is the registration under 15 of the Special SMA. That is only a registration. Our marriage was solemnized during the year 1994 according to Sharia law. Here, but the gift, my last girl, and she is aged only 14. If I am gifting my property is not only the immovable property like building or house or land properties. My property including bank savings account, my car, my mobile phone, I am a practicing lawyer, my office, my books, and my file, everything is my property. I am not in a position to gift all these property to my daughters. That is very difficult. I want to be the sole owner of that property. I have the sole right over my property up to my death.
You know, Professor Mustafa, because it is 2/3, 1/3, the 1/3 goes to the male members of the relatives, essentially not the girls here, in his case, his 3 daughters. Then the question is that isn't it right to go through that route? You know, besides gifting, it is about feeling the rightful owners as well.
Maria, you can't be forcing people. If somebody wants to register his or her marriage under the Special Marriage Act, under our law, they have that right. Nobody can question Shukkur and Sheena's right to register marriage under the Special Marriage Act. The bigger question which we are raising, that there are personal laws which may be discriminatory, but we do not get the complete picture because our TV anchors don't take us to the depth of the subject. Let me just tell Mr. Shukkur, who is a very learned person and has taken a great initiative, that under the Indian law, in number of states, forget about half a share in property for daughters. They don't get a share at all in the agricultural properties. And all these agrarian laws have been exempted from the challenge of them being violative of right to equality because they have been included in the 9th schedule. This is one. 2, when we made a distinction, when the Hindu Code Bill was passed, for instance, we did not give Hindu daughters a right in the ancestral property. That reform had to wait till 2005. And then the court wrongly interpreted the law. It had to wait for another 15 years. It was only in 2020, during COVID, when Supreme Court
You are right, sir.
change. And don't forget it. Even today, if you look at the section 19 of the Special Marriage Act, it says if a marriage is solemnized by somebody who is a Hindu or a Buddhist or a Sikh or Jain, it would mean severance from the joint family.
That's
This
right.
is the law. This is the law. And you would further be surprised, Maria, if a Muslim registers marriage under a Special Marriage Act, or a Muslim registers a marriage, or say Christian registers a marriage or marries under a Special Marriage Act, personal law is not applicable anymore on them. But if two Hindus marry, look at section 21A, which was inserted in 1976 in the Special Marriage Act. If two Hindus marry under the Special Marriage Act, which is a uniform civil code, they continue to be governed by the Hindu personal law. And what was the Hindu personal law in 1976? The daughters will not get any share in the Hindu joint family property.
Okay.
It's quite a complex issue.
Yeah, it's a very complex issue, and I agree with you that time has come for anchors such as me to perhaps go in depth on this subject, and it is a subject of great interest. Certainly, Faizan Mustafa, I'm going to continue to bother you regularly. Shukkur Vakil, I'm giving you the final word. Please go ahead.
Yeah, my concern is the equal right of girls that is same to as what the boy in Muslim communities enjoyed and enjoying. But that is our concern. Moreover, in several families suffering or due to this law, they cannot enjoy, they cannot trust her relatives or other persons, and if a male child is born in that wedlock, they will get the entire property. That is a huge discrimination that is against Article 14 of our Constitution. If there is a boy,
yes,
they will get entire property. If the absence of one boy, they will lose the property.
Yes.
That is against the fundamental right of under Article 14 and Article 21. That is my concern.
Okay, thank you so much for your time, Shukkur Vakil and Faizan Mustafa. Debate which will be continuing. That's all from me. Thanks so much for watching, and I'll be seeing you tomorrow.